Good morning and welcome to the Aird Berlis LLP webinar. Our topic this morning is Managing Terminations, a practical overview and employment law update. Thank you for joining us this morning on a rainy morning in Toronto. We have over 3,000 people registered for this webinar, which means it's a big topic. People are interested in this, and we want to approach this. We have a little bit of a reference to case law, but we want to approach it from a very practical perspective. This morning joining me are my colleagues Michael Horvat and Daria Pergadova. Daria is new and has joined our department just recently. Fiona Brown is off on maternity leave, and Megan Cowan is out of town today. So you've got the group that will take you through this, and we're ready to go. So let's get this going. We do have some questions from you already. It monitors just how interesting a topic this is to you. But continue to send them in if you've got inquiries, and like we always do, we'll try to follow up with a newsletter that answers some of those questions after we finish. Here's what we're going to do today. It's kind of from marriage to divorce. We've done that before, but this is more specific on the termination itself. But we want to talk a little bit about the employment relationship from a contract and how you can shape that to deal with eventualities in the future which may lead to termination. So we're going to talk a little bit about that this morning. We're also going to review the employment relationship, issues of performance management and performance generally, and how we're going to deal with the issue of cause when we need to, always a difficult thing to address. And then ending the employment relationship, we'll talk about the elements of cause, how to conduct the termination meeting and construct the termination offers, how to avoid constructive dismissal, and then how we address the obligation to mitigate from a tactical or strategical perspective when somebody has been terminated and they're on a severance package. So without just a couple of quick notes for you this morning, remember that all of this, any termination before you do so, we're going to talk about this at the end, you should plan for this ahead of time, get HR, get legal advice before you go ahead with it. And the second thing is terminations are a part of life in the employment sphere. It's unfortunate. Sometimes it's good, sometimes it's bad. We focus on doing it properly, of trying to avoid the liability and be tactical to get to a result that you need to. All right, so that's what we're doing here. I told an executive who was terminated after many years of being a senior executive at a company, there are two rules about terminations of executives. One is they get terminated, and the second is that executives can't change rule number one. So it happens, we deal with it, we're going to move forward. Michael is going to take us through forming the employment relationship. Off to you, Michael.
Thanks very much, Lorenzo. Good morning, everyone. This is, talking about terminations and starting with the employment contract relationship is important. It is the prenup to the marriage that is employment, and protections afforded by the contract can be put in place at the beginning. It can be all dealt with at the front end. You can, as we go through this, you can determine a lot as far as what limitations or expansion you want to do on termination options within your employment contract. It really is up to the employer. It can be a product of the company's intent as to how it wants to deal with employees. It can be limited to maybe just executives or senior positions as people move up through the organization that you want more clarity as to what might happen in the event of termination. But this is your attempt and your ability to get certain business insurance with key people when they are departing. And it is something that you should consider about your future planning. Now, this can be a difficult discussion because once you're at the recruiting stage, you're already potentially talking about what's going to happen on the termination stage. That can affect how are you going to retain people, how are you going to attract people, and what are the market issues at play. Certainly, employees or prospects who have choices are not necessarily going to go to the company that limits them the greatest with respect to termination, or they feel doesn't seem to be making a commitment to them on a go-forward basis, particularly when they're talking about restrictions on their termination. But it is something that you can do, and it is something that can be more memorialized in the agreement. Of course, the best situation always is to get this up at the front end before the individual has started employment. It's not fatal if it happens the day of or the next day, but not preferential. There are some new cases out there saying that as long as the contract is exactly as what was discussed, it doesn't have to be on the day before. It can be on the day of.
We probably still recommend it be before.
Absolutely. And the other opportunity is when people move into new positions. Don't be in a situation where you feel that a regular bonus or increase in salary is going to be always considered to be consideration of putting in a more restrictive termination provision in your employment contract. The employee is always going to say, I could have gotten that raise or bonus anyway. You really didn't give me anything I didn't earn or wasn't going to get. So the best secondary opportunity is to do it when the person is promotion. Promotion time is another opportunity to say, before you get this promotion, you have to agree to this provision. When it comes to talking about termination, the two key issues here are, am I going to employ this person for an indefinite period of time or a fixed period of time? At the moment and where the courts are going, and you'll see this later in our presentation, there's probably no benefit to a fixed term arrangement. You're going to have to put in the same protections as it relates to early termination or a termination clause in your fixed term arrangement. It's better to do it on an indefinite basis and have a clear provision stating your restrictions. The downside, of course, is going to be that if you've got a fixed term arrangement, you got to monitor it, and if it goes on too long, you're into an indefinite basis anyway. Secondly, if you've got a fixed term arrangement, you could be held for the entire length of that term regardless of it.
And why do you need a fixed term? If you've got a provision in there that, for example, provides for ESA minimums, you don't need a fixed term. You can just terminate by paying ESA, which you're obligated to do anyway.
Exactly. So there's really a short-term fix only for fixed term, and it should be restricted really to situations in which you've only got a year or less of employment.
Okay, great. Okay, we're going to move on to the performance management issue. Now, this often comes up because, remember, foundationally, there are two reasons why you need performance management. One is to give the appropriate feedback. It makes for a healthy work environment. People get better if they get positive and critical feedback. But the second is also to build a foundation in a case in the event that you want to terminate for cause. You've heard me say this before. It is hard as hell to terminate for cause these days. All of you out there know that. All 3,000 of you know that. The issue is whether or not we want to be in a position. There are other reasons why having a file on performance management also helps. In the event of an allegation of disability and discrimination on the basis of disability, you can say these are performance related, they're in the file, they have nothing to do with a disability or a prohibited ground of discrimination under the code. And also to simply, if you need to kind of put together issues with the employee on performance and conduct, you can use that down the road. But remember, you have rights here. Employers think they don't have rights. If there's one thing you take away from this presentation, you have rights to performance manage your employees. We've set out on this slide some of the things that you can do. It doesn't mean that if they breach right away, you can terminate them for cause. That's not the point of performance management criteria. It is to have consistent standards that are applicable, that the employee has notice of, and that they understand. Consistency is very important to the courts, to the tribunals, to arbitrators. They want to see you're being fair. If you are being fair, right, then you have a shot. Here's what you've got to do, and here's the key performance indicators and a path to success. The rules and the criteria have to be objective and clear. They have to be clearly communicated in advance to the employee, and you have to actually set out in your PIP what the or performance management documents, what the consequences are of non-compliance. But you can't, and this we have all seen around this table, so many times when the courts have looked at a termination based on performance, and they'll say, well, a new manager came in and said, here's the quota, here's the criteria, if you don't meet it in 3 months, you're gone. That ain't going to fly. What is going to be persuasive to a court, a tribunal, or an arbitrator is a consistently enforced pattern of rules, expectations, which have been communicated to the employee. All right? Don't condone or ignore bad performance, even if it's just a note on file. Be specific and frank. All right? Be explanatory when necessary. Open communication with the employee. Now, I'm going to tell you what a lot of you are thinking. We have performance issues with employees. We have meetings with them, and then they go off sick. I get that happens. But if we don't have these clear criteria, we're not going to be able to show that we did it for good reasons rather than the fact that they were off sick, if you were considering terminating them on their return or a performance management plan. So let's base it on real numbers and real facts. Let's be reasonable, let's be communicative, and let's be clear. All right? So what are the keys, again, to performance management success? Respond to similar conduct in a similar manner. If somebody parks in your parking spot, that is not reason for termination. All right? If they key your car because they're in the parking spot, it might be. So let's look at the context. All right? Clear and specific instructions for improvement, offer guidance, give a timeline that is reasonable in the circumstances. This applies specifically, and Michael and I have gone through this before, where you have salespeople. You can't just jack up their quota and say, if you're not meeting it, you're gone. All right? Acknowledge problems, acknowledge improvements. All right? Warn of specific consequences, and for crying out loud, keep your documentation. Keep the file. All right? It's necessary, it's important for a lot of reasons, not just to justify just cause termination. So that's kind of in a nutshell my point on performance, but Daria is going to continue on a little bit. Daria?
Thanks, Lorenzo. Lorenzo did touch on some of this, but even this morning we've read a couple of questions coming in from some of the participants about the differences in which performance should and can be assessed in a unionized environment versus a non-union environment, and it certainly does differ. In a unionized environment, the only real option is progressive discipline, or in other words, discipline that gets more serious. And like Lorenzo said, documenting that performance management and your approach to assessing performance is really the only option. In a non-union environment, while progressive discipline is also an option, it can be a lot more difficult. It takes more time, and at the end of the day, it's a bit of a risk-benefit analysis where such a plan and an improvement process can actually be equal to or greater than it would take just to give the person reasonable notice. So it really is a bit of a cost-benefit analysis. Now, the key takeaway on assessing performance in general and any kind of performance improvement plan is just to really understand why you're doing it and being fair, consistent, and reasonable. So you can ask yourself, we've laid out some questions there, is the PIP an effort of rehabilitation truly, or are you just trying to create a paper trail to ultimately terminate for cause? And what happens if the PIP is rushed, if it doesn't allow the employee the opportunity to show self-improvement? Then that actually can weigh against you pretty significantly. Also, a consideration is, what if the employee shows some kind of improvement but not quite to the extent that the PIP was meant to induce? And in that situation, you are going to have to make a decision, and it can be quite difficult, of whether you stick it out or whether you ultimately terminate. So again, just the takeaway on it being, understand why you're doing it, be consistent, and be clear in your objectives.
Great, thank you, Daria. So let's move to termination, because, and I say this to clients all the time, have a plan, have an approach, all right? What's consistent with your culture? What do you want? How do you want to deal with termination issues when they finally kind of crystallize? What approach is your organization going to take? Is it a without cause, or are you going to kind of, in those situations where you believe that you have cause, assert that? Or are you going to allege cause but provide a payment anyway, or zero payment for cause at all? In most cases, I would say in the highest percentage of cases, most employers will say, we're going to look at a without cause approach, just because of the amount of human resource that it takes to simply establish a cause termination. But if you're going to take a without cause approach, how are you going to do it? You know, are you going to pay ESA only, force them to sue for the rest? Are you going to do something in the ballpark of reasonable notice? For example, we recommend often the low end of reasonable notice at common law. Are you going to provide working notice? And I had a question just late last night on a termination of an employee, and they want to put in working notice for a long period of time. And then the question was, well, you're going to have a pretty unmotivated employee. Are you prepared? Do you know the employee enough? Is your culture accepting of the fact that even if they're on working notice, they can be productive, not disruptive, not a problem with respect to accessing files? All questions you have to ask yourself. And then what's your temperature for litigation? If you're going to take one of these approaches, ask your lawyer, what are the options? Are we going to get a loss? Are we going to get a claim? What are we doing here? And are we worried about that from a reputational perspective? Daria?
Yeah, so we're going to talk briefly about termination provisions in an employment contract. The employee's entitlement upon termination is limited by a properly drafted termination clause. We write that there, and really what I've underlined in circle is properly drafted. We see many termination provisions, but for one technicality or another, they end up not being enforceable. So we've laid out some things here which will increase the likelihood of them being enforceable. Most importantly, of course, is the fact that the clause must provide for entitlements that are equal to or greater than the minimum ESA requirements. In other words, you can't contract out of the statutory minimums. However, and this is what most often is missed, is that the clause must also expressly continue all benefits for that notice period and include a very express waiver of common law reasonable notice entitlements. Something that we've found has worked really well is using a formula. So something that is greater than the ESA requirements, but not quite as high as the common law requirement would be. We've recently started using a table of sorts, so where you're actually going to see the number corresponding to the amount and years of service. As well, providing this may be common sense to all of you, but it is unfortunately at times forgotten in a rush situation where the contract needs to be executed yesterday. Providing the employee with an opportunity to obtain ILA is obviously something we want to ensure. The last message there is that absent a clear termination clause, you're always going to end up that the employee is entitled to common law reasonable notice, which is might not be the intention, but that is the fallback if it's not properly drafted.
And if you're putting if you're having a salary continuance payment there and there is a mitigation obligation on the employee with respect to that salary continuance, you've got to write it in the contract. It won't be assumed.
And then you've got to follow up on it. And that's where you're going to get pushback. But you have to be able to follow up on it and say to the employee, we need constant information from you so that you're disclosing to us when you're getting your replacement position.
Absolutely. Daria?
Yes, so obviously when you're terminating, the key consideration or one of the key considerations is whether that termination will be with or without cause. In a non-unionized workplace, you have an option to terminate the employee with cause or without. You can avoid notice requirements when the termination is for cause, but not when it is without. And obviously, when it's without cause, you're going to have various considerations that you'll need to consider, such as notice and severance entitlements, continued benefits, as I already touched on, also any kind of bonus, and also any kind of outplacement counseling. So this will obviously depend on the workplace and to some extent resources, but these are all things that are considered in a without cause termination. Unfortunately for our friends who are dealing with unionized environments, the situation is quite different, and absent a layoff for lack of work, you can only terminate for cause.
And any agreement with respect to a unionized employee needs to be done through the union. So if you want a settlement, a payout of a grievance, or even just an agreement that the individual will leave the employment of the employer, then you have to actually do that through the union. They need to be participatory. Michael?
And just to follow up on that one, thank you, Lorenzo. Just to follow up on that point, I do get questions from clients with unionized environments as to whether they should be disclosing their communication with their employees to the union, and my response is yes.
Yeah.
They don't have, unionized employees once they're part of the bargaining unit, they don't have the same confidentiality protection in respect of their employment terms. And so if you're engaging in your discussions with your employee about accommodation, frustration, attendance, keep the union informed, because you're going to be at some point either terminating this individual or settling on a matter where the union needs to be a party to that settlement. And it's a lot easier to do that when the union's been kept in the loop the entire time. So with cause situations, and we're getting these questions quite consistently, well, what's left? When can I terminate for cause? And on its face, not many things will get you cause anymore. Theft clearly will still get you cause. It doesn't matter if you've taken $1, $10, or $1,000. Judges and arbitrators still consider theft to be a fundamental breach of the contract. Harassment, particularly with the changes to the OHSA, is now also in that sphere of automatic termination or justification for termination. After that, it gets more specific. If you have a situation in which you've got an employee on a poor performance and that employee has only been with you for 2 years and you've managed them properly, you can still terminate that employee for cause and have a judge or an arbitrator uphold it because they're reflecting it over the period of time that the person's been employed. If you've got a 20-year employee, it's going to be extremely difficult when you're discussing and saying, well, for 19 years we sort of muddled through with this guy and we never really disciplined him, but for the last year it's gotten really problematic. That is a really hard thing for an arbitrator or a judge to swallow, that somehow in the last year this guy has now accelerated to the point of cause on a bunch of little elements. It's always going to be more difficult when you're looking to try to pick out the culminating incident or the straw that broke the camel's back in respect of a termination. Always remember that when it comes to cause, ultimately you have to prove it. So the employer has to be able to demonstrate it. In unionized environments under arbitration, the employer has to go first and actually prove the elements of cause. And so document, witness, investigation, all important facets if you're going to go that route. And so really it's going to be about consistency. Have you treated your employees consistent, and have you treated them according to their position within employment? It's going to be also a situation where before you engage in a cause termination, understand what that's going to be to morale. Is this person otherwise an individual who might have been given the benefit of the doubt by his colleagues and are not going to be too appreciative of a termination for cause? And that may lead you into a situation where you might want to consider performance improvement. So when you're talking about termination, is it proportional? Look at the record. What warnings have or haven't been given? Whether or not a performance improvement plan is appropriate in the circumstance. It really does come down to determining, does the punishment, and understand that arbitrators and judges unfortunately take this as the equivalent of the employment death penalty. So they take it very seriously. So the offense has to be supportive of the fact that this person doesn't deserve further either employment in a unionized environment or payment of their severance in a non-union environment. It's a really detrimental effect on the employee, not least of which is just the emotional and reputational effect of having basically a hole in their resume because they just got terminated for cause. When it comes to progressive discipline, the most important thing I feel is that you need to be clear that the employee has been given a clear and final warning. Try to avoid the last letter also being, future discipline up into and including discharge. If you're at the last step with this person, make it the last step. Tell them this is it. This is your last warning. That is going to be even more important in proving it because the employee will have, I Love Lucy, they'll have some explaining to do to a judge as to why they didn't take that final warning to heart. Remember that you can't use termination just for a negotiation ploy. Now remember, that doesn't mean that you've got to prove termination beyond a reasonable doubt. This is not a criminal standard. You could have a good faith view that this person should be terminated for cause and have everything in order, and a judge or adjudicator could disagree with you. That's not bad faith. You can go with that position throughout as long as you're prepared to go to trial, but you can't use it just as a litigation tactic. We don't think we got the goods on this guy, we don't even got the proof, but we're going to assert cause anyway because that's going to give us some leverage in negotiation. That's where you get into risk with respect to bad faith damages and reputational damages.
Great, thanks, Michael. So let's talk about the meeting. You've come to the conclusion, and I always say to clients, when you are trying to determine whether or not a termination should take place, whether it's virtually on your computer or you go to Staples and get a binder with 50 tabs, get all the documentation in place, put them in chronologically, and then that's what you review with the HR as an HR professional or with your counsel. Put it together in a way that you can look at everything at one time so you have context, you see all the discipline, you see whatever the numbers are, if there were sales numbers or whatever. Once you've had all that discussion, you've come to the conclusion that you're going to terminate, you've got your letter, talk about that next. The meeting itself, I think, should be really simple, and I get a lot of questions on this, but it should be really simple. Look at it as if you were, whether the employee is a bad employee, good employee, indifferent employee. Look at it as if somebody were terminating somebody in your family or yourself. Treat them with respect, all right, and not with kid gloves, but be respectful of the fact that this is going to be a real difficult day for them. It's probably going to be a difficult day for you as well. When you do it and where you do it, there's lots of debate over this. Lawyers will tell you all the time, don't do it on a Friday, don't do it on a Monday, don't do it on a day where it's sunny, don't do it on when it's rainy. The bottom line is this: keep it away from other employees, all right, if you can do it. Do it, I will usually say do it at the end of the day. Make sure that there's transportation available. Have 2 members of management at the meeting. Many clients ask us as lawyers whether we'll do the termination. We say no, because that actually puts us in a position where we could be witnesses of any allegation on how the termination meeting took place, all right? But have a plan in place. Have resources. Outplacement is not a legal requirement, but it is often a good idea to assist the employee in getting on their feet, all right? Be concise and compassionate. Don't get into a debate about why the termination took place. If it goes off the rails, end the meeting. Determine ahead of time if you think security is going to be an issue, all right? But you should always have a plan as to whether or not they're going to go back to their office and pick up their personal belongings, or some of them, how that's going to be handled. Are they going to have access to to the computer and to employment files? Company files should be cut off almost immediately. Access to the building should be cut off immediately after the termination. But make sure that you have a plan in place on how to deal with it. And if it does go south, end the meeting. Don't engage in a debate.
One additional tip, if you've come to the point where you've determined you're going to terminate this person with or without cause, don't wait. A lot of things can happen in the period of time between when you've determined that you want to consider cause and you've come to that decision, and then when you delay before you have the final meeting. Employees have a sixth sense about this. They see it coming, and your more difficult employees will make it even more difficult for you if you give them the opportunity on the delay factor. All of a sudden, things happen. All of a sudden, they've gone and they're under stress, or they have other issues that come up that now you call us and we say, wow, that changes the factors that you have as far as the opportunity that you had, particularly if you're in a situation where you didn't document as well and you hadn't prepared as well, and you were going to go forward with without cause termination, so you're going to give them a package, but now that's almost off the table because you waited.
Good point. So termination offers, these are something that you're going to look at, perhaps discuss with counsel. If you're going to look at working notice, you got to make sure that that's going to be an appropriate I think, option with the employee. Many employers don't want to keep working notice because you're going to have an unmotivated employee. But sometimes, particularly in senior management positions, they will assist in transition, or you may need them to assist in transition. My advice is do that for as long as you think you need to. Most employees, working notice can be used as a bargaining tool to say, well, okay, if you don't like our package, then maybe we don't make you work and we pay you instead, but we ain't going to give you your entire common law notice because you don't want to work. All right, but is that going to be a productivity issue, a morale issue in the workplace? You can't use working notice to offset severance pay under the Employment Standards Act. All right, but you know, and you also have to be very aware that if you give working notice, as Michael said before, you can often have people who go off. The stress, there can be an injury. In many, and you might find in a manufacturing facility, people might hurt themselves all of a sudden. So you got to be careful about that because there's other things to consider.
And statutorily under the Employment Standards Act, the notice period under the ESA, even if it's working, has to be completely paid out. So if the employee is sick or absent or goes to an interview during that notice period, you still have to pay them. They don't get any diminution on that notice payment.
Good. Thanks, Michael. Now, so what's the offer going to look like? Is it going to be salary continuous? You've seen these offers. We're going to pay you for so long, 50% if you find another job. Some trigger that obligation if they find another job with a certain percentage of their income. We can be creative on that. I generally recommend a clawback provision on salary continuance. If plaintiff counsel or the employee wants to negotiate a lump sum, that's fine, but we're going to take a discount on that because you may find a job tomorrow and then you get both payments. So if you want to keep more money in your jeans that way, then we're going to get a discount on the salary continuance. Lump sum is what most plaintiff counsel prefer. They don't want salary continuance. They want to get their pound of flesh from the plaintiff, right? They want to get their money up front. They want to get it quickly. They want it in a lump sum. And they're going to get less if there's a salary continuance in most cases. So they're going to negotiate back to a lump sum, take the advantage on that. It's important that we understand that the obligation to mitigate is as if they had been given working notice. So if an employee's under an obligation to go out and mitigate, okay? So either way, though, I think what you've got to look at is you need an offer in writing. It needs to be given to them on the day, and they need to be given time to review it, all right, to take it away and review it. Lots of clients say we don't want to give them the chance to get legal advice. They always do anyway. So if they're going to get it anyway, but our letter says nothing about it, we'd rather have the court say we gave them the opportunity to get independent legal advice, all right? There's got to be benefit conversion language in there if they have benefits, right? And you should clarify, as Michael said earlier, with the benefit provider what you can and can't do. Most benefit providers will say, a lot of them will say we can't extend group health and dental beyond the 8-week period. I'm calling BS on that. They can, all right? They're your benefit providers. You can arrange for that. STD and LTD, they will stop immediately, and Dario will be into that. Offer an employment reference letter if possible, even if it's just a letter of employment that will be answered consistently. Remind them of all their obligations on confidential information and return of company property, particularly if there's intellectual property concerns. Are you taking their phone back? Are you taking their computer? Do you own that material? Do they have personal stuff on there? All of these things have to be considered in advance. And Dario will talk a little bit more about the offer.
Yeah, so two areas of termination offers that we get a lot of questions on and that tend to be slightly more complicated or nuanced are benefit continuation and the release. And like Lorenzo said, and like we've touched on a little bit, an employer is, of course, required to continue all benefits during the notice period, and that's both statutory and common law. But we do run into situations where a lot of insurers will state that they cannot or will not continue disability benefits beyond that statutory notice period. I don't know if I can speak with the same level of confidence with Lorenzo, who calls BS on that, or perhaps I will at his stage in his career. But the key message, unless this is addressed, the risk falls and the burden falls on you, the employer. And so it must be addressed clearly and ahead of time. Mitigation strategies around this are stating clearly which benefits continue or which do not, and the duration of the coverage. Also, if the employee doesn't accept and sign a waiver, it's important that you think about this ahead of time and have a bit of a plan. For example, securing LTD for the individual. This can be really costly. It doesn't happen often, but we do like to put the factors out there and put the risk to you because it is just that. It's a risk. The termination letter should also set out any kind of group or life insurance conversion options where the employee will have an option to convert to an individual plan. Moving on to the release, if the termination package includes an amount that exceeds the ESA minimum requirements, then absolutely the employer should require a release from the employee. However, that release has to be mindful of specific language, for example, human rights claims, and we will touch on human rights considerations later on. If the contract already included a release or a common law waiver, the employer can demand that an additional release be signed or one is not required. Some other things that we've identified that often go in termination letters are commissions, mitigation reporting, pension and RSPs, car allowances, as well as some other things. The key there being is we don't necessarily recommend that this termination letter be as long as the original employment contract, but the more that the employee is entitled to and the more complex their employment agreement, the more benefits they have, chances are these are all things that they're going to be thinking about if they are being terminated. So we've set some of those out here, and the termination letter could take those into account.
And just to follow up on one item with respect to continuation of insurance plans, don't be afraid to contact your insurance company. Remember, they're your clients as well. They're servicing all of your employees and they're servicing you. So you can, under the terms of your plan, in accordance with your plan, still push back on them as to what they can do to assist you with respect to maybe potentially problematic employees, and to give yourself some extra leeway in negotiation.
Great, thank you, Michael. Now, just a point on stock options, RSUs, PSUs, stock options. Get the plan before you do the termination letter. Understand what it says about the termination of those, of vesting and accrual or payment, and how they have to dissolve post-termination. Most plans have provisions in there that deal with what happens on termination. About 20 years ago, there was a case that talked about the fact that the plans had to be read in accordance with the common law in terms of defining the termination date. Otherwise, it could go through the reasonable notice period. Most all plans have been updated, but know and understand so that you can put in the letter exactly what happens with respect to RSUs, PSUs, stock options. Very important that we make it clear, because those often are the case of, are the subject of litigation, because that's where the big money is, quite frankly. It's not the salary continuance, it's the options and restricted stock units and things like that. So, want to talk a little bit on the next couple of slides on constructive dismissal. We know that constructive dismissal has been defined as a fundamental change to the terms and conditions of an employee's employment. That can show itself in a number of ways, including a change in pay. There's a recent case that just talked about a 12% decrease in pay cumulatively or independently as triggering a constructive dismissal claim. But it can be a loss of benefits. It can be a combination of loss in pay and benefits or perks. The example I use is, again, if to use the parking lot example, if I take from the VP his parking spot away, him or her away, then I don't think that's constructive dismissal. If I tell them that they're going to go from VP to receptionist, even though they get the same pay, that's a constructive dismissal. Now, there is an obligation for the employee on constructive dismissal to ask questions, to determine the job and what it is and what the duties and pay are, and then to mitigate if mitigation is necessary. There's a question of whether or not the courts will decide whether it's humiliating, or there's an egregious breach, or there's harassment or whatever, a poisoned work environment. But we like to put the employee to the test on that. So when you're making changes to avoid potential tips, if you've got a strong performance management and your company policies are up to date, we can actually avoid that by saying, we've talked to you about this, there is no change, we're just performance managing you. And if you're gonna offer either a temporary position or a change to the terms and conditions of their employment, and this is in the next step, tips to avoid potential claims, we advise that you tell them about it. Be very clear about it, have the discussion with them. You may need to give notice of that change, or you may need to agree with them on what the terms and conditions going forward are. If your employment agreement has a change of duty or a suspension clause, we should look at that, because an automatic suspension when there is no right contractually may trigger a constructive dismissal, even though it's only for a loss of that period of time. So those are the kind of things that we have to look at. But constructive dismissal is a difficult thing, because a lot of employees will get advice by plaintiff counsel who will take them through the process while it's happening, write the emails for them, tell them what they got to say, and then trigger a constructive dismissal, because they know they have another job, or they just want to get a severance package. So let's be careful about that. Michael?
Just one additional point on the constructive dismissal. It's an individual determination. I get these questions quite often. We're moving our location, our office from Markham to Woodbridge. Is that a constructive dismissal? It's going to be individually dependent on each employee. To some employees who live out in the West End, that'd be great. It's wonderful that the location's moving closer to us. For people who might live way out east, it's added in an hour to their commute time, and on any basic measure is considered a constructive dismissal. So while some employees will be happy, some will not. So you can have a divided workforce with respect to constructive dismissal, and as Lorenzo points out, that's where notice comes into play. If you are going to be moving, then you should know about it, and you should be able to advise employees of it and give yourself some lead time so that you at least have the defense of providing your employees time to adjust to the change in circumstance. With respect to mitigation, we've talked about it before. It is clear, a matter of law, that employees who are dismissed must take reasonable steps to obtain comparable alternate employment to maintain their right to damages. That means the judge can actually say, you didn't take an opportunity to mitigate, so your damages either end at a certain point in time, or you actually don't deserve any damages at all because you just sat at home eating Cheetos and didn't really look for work. Clearly, that's going to depend on a lot of factors. Whether or not the employee is senior or not, how many jobs are available, what locations. A lot of factors go into play here, and not necessarily to the detriment of the employee. It's the company that bears the burden at trial to prove that mitigation wasn't achieved. And that's a really difficult and can be a very costly situation. For most employees and actions, it's not going to be actually worth the money to invest in proving that mitigation wasn't there. For certain senior employees who are earning significant dollars, it could be. But for most average employees, it's not going to be. So really, we're talking about sort of moral suasion here and using it as a settlement or negotiation tool to say to the employee, you're probably going to get work soon, and this is why you should take the discount. When it comes to dealing after termination, you can always deal with the employee directly. There's still your relationship with them. Oftentimes you'll find that some of the demand letters comes in either from the employee, or it looks as though the employee has gone to a lawyer but hasn't necessarily engaged a lawyer to respond. Really, it's tactical at that point in time. You can continue discussing with the employee about settlement tactics, including having spoken with your own counsel, or we often write letters on behalf of employers who then send it directly to the employee. Understand that, unfortunately, once both parties have gotten counsel, lawyers can only talk to lawyers. They cannot talk to clients directly. You can always change the severance package on negotiation. Really, it's about whether or not you think you've got the flexibility with a particular employee, and quite frankly, they may not be asking much. When it comes to references, always agree on at least what your oral or written reference is going to be, and if you're going to take the position that you're only going to give a particular reference, then stick to it. Don't have anyone else change it if there's any calls that come forward. When it comes to other people, suppliers, employees, stick to limited explanation. This person is no longer with us. If you have a question, this person is now taking over, or in the interim, all questions can go to someone else. Do not engage in any discussion, particularly if the reason was cause. Even if you're getting a call from another employer, you stick to your script with respect to any discussion. And when it comes to outplacement counseling, get approval from the employee. The employee may actually want you to speak with outplacement counseling so that they can network and utilize your connections, but get permission first. If the person doesn't accept the release and doesn't sign, you still have to pay ESA. Unless they're telling you not to, those payments should be made within 7 days or the next payment period. Remember that you can go forward with agreement to hold off on that, and you always get credit for whatever you've paid. So even if by mistake or by plan you've determined that you're going to provide your severance payment to the individual anyway, you always get credit. They don't get to double dip on that compensation.
And you can't hold a, remember, if you're making an offer of just ESA, all right, on a without cause termination, you can't make them sign a release. All right, the release will be deemed invalid because that's their entitlement. But if you offer more than ESA, you can. So the question is, are you offering more to get a release in exchange? And if you're going to offer more to get a release in exchange, it has to be an offer that makes sense. Otherwise, if you're saying I'm going to give you another $10 to get a release, they're going to go tell you to pound sand. But if you want to be in a position where you can say, look, we're going to give you a little bit more, but we want a release in exchange, that's how you would do it. Just a couple more comments about after the termination, and then we'll get into some human rights concerns. You know, don't, as much as I know that employees can do this on social media, although our releases have non-defamatory and our offers generally have those provisions in them, don't get into a conversation, social media otherwise, or even with other executives or employees about the employee. We just need to let that one go, all right? Make sure that we get all the property back. It's very important, particularly if there's issues of confidentiality. know exactly what that employee did or didn't do. If there's holes that they have to fill with information or documents, check the server, see what's on there. Know how you're going to respond to, it should say employment insurance, we've changed that, but unemployment insurance inquiries. And that is, do you care if they get unemployment insurance? But even if you do care and they get it, and they ask you if you want to appeal, oftentimes what we advise employers to do is send a letter saying, we don't agree with the determination, but we've chosen not to appeal, so they can't use that against you down the road. All right? So be very, be smart about it, but just let it go if we have to. From a human rights perspective, and this is really where I tell clients, and our advice generally is, performance management, issues with respect to, all of that should be in the file anyway. Because if they allege, even if it's a without cause termination and you give them a package which is fair, the employee may say, well, look, you terminated me because on a prohibited ground of discrimination, and I want extra damages. If you've got a performance management file that says, here's all the things they did wrong, we can point to it and say, yeah, we get that you're saying that, but that's not why we did it. Look at all this documentation. Make sure the file is complete, all right? When it comes to, we know that you can't select based on prohibited grounds, all right? But if you're going to do things like layoff or termination on a restructuring or a downsizing, have internal logic. Otherwise, it looks like you're picking and choosing. How are you doing it? Is it seniority? Is it skill retention? Is it location? Have that set out before you go in there. Have it in the file so we can defend against any allegation that, well, you picked one person because she's 63 and you let another person through because she's 42, all right? We need to understand that that's a risk. Daria?
So when faced with the situation where you have to reduce headcount or reduce your workforce, voluntary reductions, for example, such as early retirement plans, must be just that. They must be voluntary. The other thing is that they must be open to a broader section of employees than just one. It can't be perceived that you're targeting a specific group or employee with that reduction strategy. However, you can limit the strategy with reference to retention of business-related skills. What you have to be mindful of is that the employees that you want to keep on for that reason are the ones that actually do so voluntarily. So they can't be denied that same option for any other reason. In specific circumstances, for example, like job-protected leaves, employees can enjoy a preference to retention. And that begs the question of how long do you have to keep them on when they return to work? There's no legislated minimum obligation. However, it has to be a material return to work. So certainly judges and courts are alive to what material return to work means. With specific respect to protected statutory leaves like maternity, paternity, and other ESA leaves, you have to give, there is an obligation on the employer to consider an alternate position if the prior position has been eliminated. This can require the employer to wait until after the expiry of the leave and consideration of any alternate positions before the termination is final. So can that employee fill any other position? What other skills do they have? There's also a benefit. This also acts as a benefit of the employee as their EI benefits are not reduced by notice and severance, and they receive the severance period to find other replacement work. Under WSIB, there is a statutory obligation to reemploy unless and only unless the termination of employment is not related at all to injury or accommodation, which is a steep hill to climb. You really have to demonstrate that, or it can easily be interpreted to not amount to that.
Yeah, and on the WSIB, remember that there's nothing that the employee gets out of that. They can get benefits, but any penalty is assessed goes into the WSIB's coffers. So, but it is often used as leverage by employees who are, you have to get that period two years from the date of injury. Otherwise, they can make an application for reinstatement. Now, I will tell you, it doesn't happen very often. It used to happen quite a bit. Michael's nodding his head. But it doesn't happen very often, but it's certainly a risk you have to be concerned about. Want to have a quick word? We could do a whole thing on frustration of contract, got to say. But Because most employers say, look, this person's not coming back to work. Can't we just say that's frustrated? All right, couple things. Number one, at common law, the rule is you work, I pay. All right, if you can't work, I don't pay. That's frustration of contract. But you have to now weave in and fold in the obligations under the Human Rights Code, various human rights legislation that says you must accommodate to the point of undue hardship. So for people who are on disability leaves, long-term disability, short and long, we don't generally recommend to terminate before the 2-year period is up if they're on an approved leave. If you are going to take the position that it's frustration due to disability, make sure you've got all the information and make sure that their medical condition, there's a little bit of a debate on this, but that you know before you pull the trigger that they can't come back to work to their regular duties or accommodated employment. You have to make a determination as to whether or not there is accommodated employment, but that's the way we work it because it does reduce the risk. Remember, too, that on a frustration of contract, even if you can prove it and you've hit the targets of undue hardship, you still got to pay your ESA, right? So you don't get out of paying ESA and you can't give working notice to a person who's off on disability. Remember, too, on a frustration of contract termination, where there's a termination and a package, the insurer generally under most policies will claw back the amounts that you pay. They'll say, thank you very much, we'll take those and still give them the benefit. Understand what your policy says. All right, we're going to get into a little bit of case law, and then we're going to go into some questions. We have a ton of questions, but we wanted you to hear some case law because there's some really interesting cases. Take it away.
So we'll start first with DAW and the equitable life insurance. This is a situation in which an individual, senior individual, 62 years old, 37 years in the position of senior vice president, was given a comprehensive package termination of 24 months and didn't think it was enough and sued for 30 months, essentially to bridge him right to age 65 when he, quote, planned to retire. This was accepted by the trial judge as being implicitly a valid reason for going up to 30 months. On appeal, the Court of Appeal said no, this was not an exceptional case, and the general rule or principle of a 24-month maximum applies. That doesn't mean the courts can't get over 24 months, and they have in the past, but this is a good demonstration and good for employers. The one thing that's problematic here, quite frankly, is not the legal determination and the result. The practical issue here is that you had a company who did basically everything right and still got dragged to court and the Court of Appeal in order to justify their original package. It is a practical issue that, you know, if they sue, you have to defend, even if you're, and the costs can be potentially not worth the fight. Particularly since employers are more often than not the ones who are going to have to foot the bill in respect of that legal fight, and judges hate putting it on to employees. So even there is no protection against an employee who wants to fight, and so sometimes that actually can go into your consideration of what the package is going to be. I often do ask clients, well, how much of a problem do you think this employee will be? Will they take the package and go if it's reasonable, or do you think they'll fight regardless? And unfortunately, if they're going to fight regardless, then you do lowball them to give yourself some extra room in negotiation.
The other case we want to touch on is the McGinty Funeral Home case, which really demonstrates the risks and benefits of fixed-term contracts. In this case, Mr. McGinty was an owner of a funeral home which had been in his family for 3 generations. He eventually decided to sell his shares in the funeral home to a numbered company, but as part of that agreement, he also entered into something called a Transitional Consulting Services Agreement, or TCSA, under which basically functioned like an employment agreement, under which he was to stay employed with the funeral home for 10 years. Now, long story short, some issues arose and differences arose between Mr. McGinty and the new owners. Within 11 months, he had gone on a medical leave, and I believe when he came back, his picture had been taken off the wall. It basically felt like he was constructively dismissed, and that's exactly what he claimed. He brought a claim saying that he was constructively dismissed, and as well a claim for breach of his consulting services agreement. So cut to the decision where, in fact, it was determined that his employment was constructively dismissed. And since the employment agreement, or excuse me, the consultancy agreement did not contemplate any kind of early termination of this 10-year agreement, the court held that he was entitled to receive all of the compensation and benefits he would have received as if the contract had been completed. That left about 9 years worth of damages, which amounted to $1.3 million. So obviously a case that demonstrates very seriously the potential benefits, but also the great risks that can come with a fixed-term contract, and the takeaway being that make sure that those terms are clear, but also flexible.
And plaintiff counsel are dying to use this case. Sorry, it's a little funeral parlor joke. Go ahead, Michael. We got one more case.
Yeah, the last case that we'll leave with you is the Metaswitch case. This is another case of courts being very particular with respect to upholding fixed termination cause provisions with respect to ESA only. They are always going to scrutinize these clauses, so it's really important that you have legal review them and be aware that the laws can sometimes change over time, so you have to update these regularly, because the courts are clear. They will not act as fixers for employment contracts. If there is a vagueness or an inconsistency, they will simply strike down the entire clause.
Great, thank you very much, Michael. So we're going to go through a couple of questions, but just our last closing slide is there's planning, understanding, but honestly, manage the process, don't let it manage you. All right, employees are going to be upset, we know that. Let's deal with also the impact on them and the organization. And don't panic, get advice where you need it, plan it, execute it, deal with anything that comes up. This is a business decision. You got to make it like a business decision. So that's our presentation for today. You can use that last slide, put it up on your desk. And we're going to deal with a couple of questions. There are many questions, and we're going to actually, it's going to take us some time. But before we do, I want to do one thing. Our Workplace Summit is coming up on Tuesday, November the 12th. That is a half-day Workplace Summit. If you're interested in it, let us know. If you're a client and you want the early bird discount, please email rsvp@airdberlis.com. We'd love to see you there. And Michael's going to deal with a question. Yeah, I'll get you. Yeah.
We've got one question that came in with respect to progressive discipline. What happens if it's for different issues and different events? Can you still progressively discipline? Absolutely, and you should not multi-track. So if you have situations where the person is being disciplined because they had 2 tardies in the same week, and then the next day or a couple of months later, they're insubordinate to a supervisor, absolutely progressively discipline on that basis. Any culpable behavior should be an advancement of the progressive discipline policy. You don't want to get stuck, and don't hear it either from a union steward or from the employee, well, that was for a different thing. I didn't know I couldn't yell at my supervisor. That's not an excuse. Move the progressive discipline along.
Good. And got a couple questions about cause. There was a question about near cause for American employers who still implement that. There's no such thing as near cause. There's cause or there's not. If you can't prove it, there's going to be damages. If you can, there won't be. But near cause is important when you're defending against an allegation of discrimination. So you still keep the file to ensure that it is there.
We did get a question in as well from federal employers and those who are subject to the Canada Labour Code. It is different from this perspective. Under the Canada Labour Code, employees, including non-union employees, have specific provisions of protection under Section 240. They can file a claim and basically challenge even certain classes of employees can even challenge with notice termination on the basis that it should have been caused. If you're not in a reduction of employment layoff situation, you can be challenged under the Canada Labour Code for those terminations. And those kind of cases are getting a lot broader now.
Sure.
Based on some decision of the courts recently that basically said it was an absolute right to challenge a termination.
That's a good point. One final question about terminating employees who are 60 plus. So remember, we don't have any mandatory retirement here. This is a complicated situation. However, you will find that many employees who are at that point, you may want to bridge them if they have a defined benefit plan or if there are retirement options, bridge them to a certain date. We want to avoid any allegation that the termination of that employee is based on their age, so you have to have an assessment of why they're being terminated rather than just we want to get rid of them because they're old. And we can bridge understand if there's a pension, what you can do with the pension, what the options are. That's going to be an important piece to the puzzle before you do it.
And finally, a couple of questions came in. If you're in a clear reduction in force, closing, departmental closing or departmental move, you absolutely can terminate people who are off on WSIB or mat leave or LTD, because clearly the reason for their termination has nothing to do with their leave situation. But what you can't do is you cannot take the benefit of WSIB or the LTD as an offset for what you're obligated to pay them. You're still obligated at a minimum to pay them all their statutory notice and severance. You cannot take a deduction because they're actually earning insurance monies, and arguably you should still pay them their common law in those situations, depends on what your contract says. You don't get the contribution holiday, but the insurer might.
Absolutely. So thank you. I'd like to, we're going to wrap that up. On our resource page, though, if you do want to register, you can go to the resource page, click on the link, and register independently. So we encourage you to do so and hope to see you there on November 12th. I think that's going to be a great seminar. You'll get to meet everybody, including Daria. And on behalf of Aird Berlis and all our team, our marketing team, and Michael and Daria, would like to thank you for, again, participating. This is always a lot of fun for us to do. We appreciate your continued support and patronage. And if you've got any ideas on what we can do better or what you'd like to hear more of, please send them in. We are going to follow up with a little bit of a note on some of the questions that we couldn't get to, and we always apologize. We're going to probably do a webinar soon just answering questions. I think it's probably time for one of those. But again, thank you. We appreciate it, and have a great day.